violence offenders. Livia was appointed twice to a judicial district bench, first by Governor Rick Perry in 2005, and then by Governor Greg Abbott in 2017. Livia is very active in educating the community with the legal concept, and she has given a lot of good advice to people to save their lives. She's service-oriented and cares for people very much. So now let's welcome Livia to give us this very important information. Thank you.
Thank you, Li Wei. I appreciate that introduction. I appreciate everybody taking their Saturday afternoon to come here and listen. And hopefully I can just plant a seed this evening about future plans for you. Now, I want to say a lot of people don't like to talk about wills and trusts because that entails passing away or a disability, but these are things that need to be thought about, just like you do about your children's education, about your own retirement. It needs to be thought about, because if you don't, a lot of problems could occur if things are not planned, and who suffers is your family and your loved ones. So I hope I'm able to talk to you in a very simple manner today. We're not going to make this morbid or depressing. This is a business matter. And I need you to look at it as a business matter. And what we may talk about, a lot of you may not have known. So if anything, my goal today is for you to just maybe go home and think about some of the things we talked about today. All right, next one. Just a little bit about me. As Li Wei said, I was a district judge in Dallas County for a period of time. I am a graduate of the University of Texas at Austin. I was going to be a journalist. That's what I thought I was going to do when I graduated from college. But those plans changed. I went to Taiwan for a year to study Chinese, came back and went to law school. And from there on, that's what I've been doing. I did work for the district attorney's office in Dallas County for 14 years, did a criminal defense. That is where I spent a lot of my time. But I do have a passion to help people. So now I'm trying to kind of move up to other aspects of the legal field where I can put my compassion to helping people in different areas. I love music. I've played piano since I've been 6 years old. Most of my family lives here in Dallas. So this is my mother right here. I have 2 brothers that live in the Richardson area and a sister who's a doctor in California. I love to travel. As you can see from some of my pictures, I am married to a retired judge. We now live out in the country, out in Kaufman County, but I do come into Dallas a couple of times a week to still take care of business. And as you can see up there, those are my 3 babies up there. I love animals, and those are my 3 dogs. What I want to talk to you about today is what you can do now to control what happens after you pass away or become disabled. Next one. As Li Wei said, a lot of people, if they don't know their your financial situations, let me tell you, the percentage of people who have planned for their death or if something happens to them is even smaller. About 20% of people, less than 20% of people have wills or even a trust. Oftentimes we don't ever think about things. I mean, unless you guys already have yours and you are ahead of the game. Most people just continue with their life. We're busy with children, family, work, and we don't think about what happens later on in life. But I think COVID certainly has put us into a mind frame of possibly getting our affairs in order just in case something does happen. If you don't plan now, you will have no control over what happens later on. If you do not have a will, a lot of people just think, oh, my spouse is going to inherit everything. Possibly. But if you have a blended family, and when I mean blended family, you have children from a previous marriage or relationship, you have other situations where it's not just one spouse and your children, but there have been other, those become important, especially if you do not have a will, because your spouse does not inherit everything if you don't have a will. Okay, so that's very important to know. You want to be able to control who gets what. And if you don't have a will, which I consider a roadmap of who gets what, then the laws of Texas will determine who gets what, all right? And then the other thing is peace of mind. Don't you want to know right now what you have worked so hard for and for your family, how will they be taken care of once you are no longer able to, right? So let's talk about if you become disabled. When I mean disabled, I don't mean you physically can't walk. Disability means if you are unconscious, in a coma, dementia begins to set in, Alzheimer's, what are you going to do? You haven't passed away, you're still living, but you are now not able to make decisions. Do you have something in place in case that occurs to you? Do you have power of attorney? Someone who will make the financial decisions for you until you are able to become competent to make those decisions. Do you have someone who is going to make the medical decisions for you if you are unable to? Oftentimes it's our spouse, you're married. But if you're not married, then who is that person going to be? Now that means once the power of attorney can certainly be revocable, once your disability is gone, you retain that power again. But during that time, who will take care of your finances and your medical needs? Now, if you have children, especially for those single parents, who will take care of your children if you are unable to at that time? Guardianship certainly needs to be discussed or thought about. It doesn't have to be family. Oftentimes it is family, but it can be a trusted friend, somebody you know that will take care of your kids until you are able to. Other things that you want to do. Medical life directive, that basically tells those who are making these decisions how much you want done for you. If you're placed on life support, do you want that continue for who knows how long, or you've told your loved ones, I do not want to live like that. Do not do this. That's what a medical directive is. If this is not something you've discussed with your family, you certainly need to, because it can become a real fight, especially amongst family members, if you all cannot agree on how you want to be taken care of. And it can get to be very, very emotional. And a lot of decisions during that time are made by emotion instead of what that person wants. So certainly think about that. Other things are revocable living trusts, and we'll talk about that also. It's similar to a power of attorney, but it's a different form of being able to take care of your loved ones during your time of disability. All right, Leeway. All right, let's talk about wills. If you pass away. Now, certainly a will doesn't come into play until someone dies, all right? Now, if you have a will, then you have to go through probate. And probate is the court process of determining when a person, for a court to legally recognize your death and authorize the management and distribution of the person's estate. So basically transfer assets into those who are living name. And this often becomes important, especially if you own a home together or real estate. To change the deed of that real estate, you have to have it in the name of the person who is alive, because if you share a home together, you cannot sell the home if both parties' names are on that deed. So you have to go through probate to have that transfer and the death of the person recognized. You'll get what we call testamentary letters at the end of the probate process, which will then you'll be able to bring to banks, to anybody who needs a legal testamentary letters to show that the individual has died and now assets can be transferred to the heirs who have been named in the will. Now, there are some things that do not need to go through probate. if you have things such as retirement where a beneficiary is named, then that you don't need to go through probate for that. Life insurance, same thing. Anything where when you do an account or set up something where they ask, if you die, who are your beneficiaries? Oftentimes you will not need letters of testamentary. Oftentimes all you will need is a death certificate of the individual to show someone. However, there are some who may still require a court process in order to show that a person has legally been found to have died, therefore your assets to be transferred. So that's what probate is. Now with the will, like I stated, that's a roadmap for your executor, because there will be someone when you create a will that you will name as an executor. And what that person does is make sure that what the will has asked you to do will be done. So they're just kind of the person who's going to make sure that the assets are properly given to the person who is named in the will. All right. So that's what happens if you have a will, and that makes it very simple. Now, if you don't have a will, then things get more complicated. Okay, next slide, please. Thank you. Because more complicated and more expensive, Texas law prevails. Okay, since we all live in Texas. And then Texas is one of the few states in the United States that has community property. And we're going to talk about what community property is. So there is community property and there is separate property. And that becomes important to your spouse, to your children, and to possibly your parents and your siblings. Now we're talking if you do not have a will. All right, we wait, next slide. All right, so community property is all the property you and your spouse have acquired during the marriage. Okay, that is community property. And community property comes into play if you're getting divorced or if you're going through probate. It doesn't include property that was each person owned prior to marriage. Okay, that is separate property. Anything that you have inherited, separate. Gifts made to you is separate property. And then if you went through a personal injury settlement, that settlement is separate. Even if you were married during the time you inherited something, you received a gift from someone, or you settled on a personal injury matter, that is separate property. Okay. Now, I often have questions. Well, I had this home before I got married, and now I'm married. Is that considered separate property? It is. However, if you are renting that home, let's say you're using it as an income, the income that is generated from that rental is community property. Okay. So that's the difference of community and separate property amongst married people. Everything else is considered separate. Personal property, real estate that was brought into the marriage or before the marriage is considered separate property. And how separate property and community property is divided when you pass away without a will is dictated by Texas law. Okay, and I'm going to give you some scenarios here. So if you're married but have no children, just you and your spouse, then all the community property, all the property acquired during marriage goes to the surviving spouse. Okay, easy. However, any separate property the deceased owned, and again, that's property that was acquired or had before the person married, or anything that was considered separate, a third only goes to the surviving spouse, and 2/3 goes to other family members. All right, so that's the issue. You're thinking, okay, community property, that sounds pretty good. Now, if you have children, still everything goes to the wife or the spouse, surviving spouse of community property. And again, 1/3 goes to the surviving spouse now, and 2/3 of separate property goes to the children. So the surviving spouse does not inherit everything. if there is no will. Okay. Separate property is a 1/3, 2/3 breakdown. Now, community property, surviving spouse will get everything. All right. Now, this is where it becomes complicated. Next slide, Leeway. Let's say you are on your second marriage and you have children from a previous marriage. Not having a will then causes issues with your community property, the property you acquired during your marriage with your second surviving spouse. Half of the community property only goes to the surviving spouse. The other half goes to the children from the previous marriage. Okay, and you're thinking, well, why not all children? Is because the children from the second marriage are going to inherit from the surviving spouse. All right. So surviving spouse gets half, and from that surviving spouse, their children will get it when that surviving spouse passes away. What happens to the other half of the community property goes to the children from the previous marriage, and they will divide it equally amongst them. Okay, so that's what happens if you do not have a will. And I bet you your surviving spouse is like, what? I don't get all the community property, even though I was married to this individual? No, you do not. If you don't have a will, the children from the previous relationship, marriage or relationships will inherit the other half. Okay. And then the separate property, again, 1/3 and then 2/3 to all children will be divided equally. All right. So the community property is really the big, big hammer where your surviving spouse may be like, okay, this I did not know or had no idea. And now I'm losing half of the community property that was acquired during my marriage to the deceased, and now it has to be shared with the children from the previous marriage. All right, doesn't make sense, but that's how Texas law works. And then if you have no surviving spouse, there's no community property, therefore everything is separate, and then it gets divided amongst the heirs according to the laws of Texas. So is that as clear as mud? I mean, it's complicated, but I'll tell you, if you are in a second marriage or have children from previous relationships or marriage, a will becomes very important, especially to your spouse that you're currently married to. Because if something happened to you now and you don't have a will, your current spouse really is going to be in some sort, depending on how much that surviving spouse thinks they're going to get, could end up being much less than they actually do get. Okay, next slide. All right, what's not included in the will? Anything with joint tenants with right of survivorship. There's often things, could possibly land, where you have on the deed that when I die, my ownership or goes to this person. Okay. I believe those are oftentimes filed in the deed office. So if you have a joint tenant of survivorship, you don't have to probate that. It just goes automatically to the person who's listed on that tenant deed. Pay on death or transfer on death accounts such as securities and U.S. saving bonds. Oftentimes they said if you die, who benefits from the account? Those do not have to be probated. Life insurance policies, retirement accounts, and trust assets do not go through probate. Okay, next one. All right, let's talk a little bit about trust. So trust is basically a box of your assets. All right, you can have a trust created in a will so that when you pass away, a trust is created for whomever it is you want that trust to benefit. Or you can create a trust while you are still living and move assets into that trust and still have control over those assets until you dissolve that trust. And those are called revocable living trusts. And we'll talk a little bit about that. The one advantage of trust, whether it's revocable or irrevocable, is that, or a revocable living trust is you don't have to go through probate. And everybody thinks, oh, that's great, don't have to go through court. But there are headaches of having a revocable living trust too, and we'll talk about that. All right, next one, Louie. All right, so a revocable living trust are the assets that are put in the trust are owned by that trust. So the headache part of having a revocable living trust is everything you move into that trust, whether it's bank accounts, real estate, whatever it is, you have to put on your deed, on your, you're going to have to redo a lot of things when it says beneficiary or deed, you have to put the name of the trust because the trust is the one that has to own the asset. Cannot be in your name, cannot be in the name of your spouse. It has to be in the name of the trust. So the headache is in the front end when you have to move all those assets into your trust. Because a revocable living trust is just an alter ego of yourself. It does not have a separate social security number. The social security number you will use is your own. So it's just an alter ego, all right? So if you think it's a social, you get a different social security for a revocable living trust, that is not the case. So there's no real tax benefit with a revocable living trust since it is your own ID, your own social security. Now, with a revocable living trust, you can still control all the assets. You do not lose control over those accounts or that real estate. You still can control it. What happens though is if you pass away or become disabled, you have a trustee that you have named in the trust who will then take over. So let's say if you pass away, then your trustee would be kind of like the independent executor of a will, but you do not have to go through probate. Your trustee will then divide the property that is in the trust as the trust has dictated to whomever the person who created the trust wants that asset to go to. So you could see with real estate, a home, if the deed says that it is owned by the trust, then you don't have to go through probate to determine someone's death. All the trustee has goes, the trust owns this property, I'm the trustee, therefore I can sell this property or I can give this property to this individual, and then that takes care of it. So that's why you don't have to go through probate. Now, Texas is one of the few states where probate is considered relatively easy because of an independent executor. A lot of the other states require court supervision. So everything you have something done, court has to say yes or no. Texas does not have that. As long as you have an independent executor and your will is valid and nobody's contesting your will, you should be just fine. But if you want to do the trust, the headache is in the front end because a lot of people have to change a lot of things to move the assets into the trust. And sometimes they think, well, that's not worth it then. Then I would say, then you need to have a will. They oftentimes, revocable living trust is recommended if you really desire privacy. Okay, you really don't want people to know your business. You have property outside of Texas. Now, this is very important. If you have property outside of Texas, if you do not put it into a revocable living trust, when you pass away, your heirs are going to have to go to the place where that property is located, i.e. California, Florida, hire a lawyer out there and have that matter probated in that state, okay? If you put your property in a revocable living trust, you do not have to do that. So that is a huge headache that you can possibly bypass if you put that property in a revocable living trust. The other one is if you have quite a bit of assets, a revocable living trust may be necessary. If you have blended families, this certainly could be very important to you also. And then if you know you're going to have family members or people fight over your will, this might be the way to go, because in a trust, guess what? Nobody gets to fight. They may try to fight, but since you're not going through probate, everything's getting passed out. And then if they're going to argue about it, then they're going to have to file a lawsuit somehow. But oftentimes that's not going to work out. Okay. So if there's a lot of discord, this may be something you want to do. All right. So next slide. All right. So again, all I'm asking you all before you leave, when you go home, is just to think about, who's it I need to protect in my life if something happens to me? Do you have elderly parents? People are living much longer now. Do you take care of elderly parents? If you do, who will take care of them, or will there be finances to make sure their health, medical, living standards are up to par if I pass away? Who's going to take care of that for me? Your children, certainly. Single parents really need to think about guardianship. Okay, who's going to take care of my kids if something happens to me? And will I have something set up where the person taking care of my children will have financial resources to tap into to take care of my kids? Grandchildren, you can build a trust for grandchildren. A lot of people like me love their pets. They want to make sure their pets are taken care of. They may form a trust for that. If you have children that have disability, who cannot live on their own, there are trusts for children like that also. But there has to be certain guidelines, because you don't want to give them too much where they would not be able to then get assistance from the government for under Medicare and things like that. Okay. And then, your business and your real estate. How to, do I want what I've worked for to be able to continue? These things need to be planned. Do you have a plan put in place if something happens to you? All right, anyway. So mainly the whole thing I'm trying to convey today is peace of mind. You have peace of mind. Can you go to bed and not worry about what happens to my loved ones or to my business or whatever is important to you if something happens to me? We all know we will die one day. I'm sorry to tell you all that. We just don't know when. We think we will live to a nice old age and die the traditional way that everybody thinks will happen. But cancer's there, accidents occur, unexplained sickness, something could happen that nobody ever planned, nobody ever anticipated. And if that does happen, will your family who's left behind be protected? That's all I'm asking you all to think about. I'm not asking you to think about death. I'm just asking you, will your loved ones and everything you worked so hard for be taken care of? Because you want to try to keep everybody, at least to make it as easy as possible during a very difficult time. And that's all I'm asking, just planting the seed there. So again, my main thing to say is at least have a will. At least have a will. You can always change it. Okay, just because you make a will doesn't mean it's forever. If circumstances change, you can always change it. But if something happens to you next week, you have something in place that will take care of everything. Because if you don't, then you need to start thinking about it. All right, so again, as you saw, if you don't have a will, you don't get to dictate what happens. All right, you don't get to, especially if you have blended families. You don't get to determine who gets what. And as much as your family may think, well, I'm the surviving spouse, or that I'm blah, 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 they don't get everything. So if you want to make sure they get everything, then you need to have a will or something in place. All right, Leland. I appreciate y'all listening to me. I know this was very general. I didn't want to get into too much specifics because everybody here has different life, experiences and things like that. But I just wanted to make sure that you understood that it is important that you plan this estate planning. Do it. do it as soon as you can. You may think, I'm too young, I don't need to worry about it. I'm saying, no, you don't, no. You're never too young, you're never too old. It is time to think about it right now. This is my information in leeways. You can always give me a call or email me if you have any questions. We are running pretty good on time. I'm here to answer any questions and answers, anything in general that you might have. If not, I appreciate your time to listen to me. You know, I'm really here to help out as much as possible, because I'm telling you, the calls that I've been getting from people on estate matters is because they're in trouble. This is not because they have a will. This is because they have been left, their spouse or someone has died unexpectedly, and now they're stuck and they need some help. Okay. Now, those that have a will, all they do is they call me and say, I need somebody to go through probate for me. Okay, that's different. But most of my calls are from people whose loved one died without a will, and they thought they'd get one thing and it turns out being something different. And that's when the problems begin to happen. All right. Anybody have any questions? Yes, ma'am.
What is considered a valid or legal will that you can just write on the piece of
Yes.
paper and give you signature?
You can have a handwritten will as long as it's been notarized or witnessed by two people who are not heirs to the asset. So you can't have your children, you know, witness. You have to have two non-involved people who witness and say this is a valid will.
So either notarized or these two witnesses, right?
Yes, two witnesses who would not be considered heirs to the will, are not going to benefit from the person dying. Okay, so yes, but you know, there are a lot of forms now online. Whether or not you want to use those is up to you. But mainly it needs to be known, you need to be competent, and everybody laughs about that and go, oh, what's competent? Well, you'd be surprised how many people sometimes fight a will because they think someone's not competent. But as long as you either have it notarized or have two witnesses, it should be valid. Now, often people say, well, I have a will, it should be no problem. I'm like, it's a document, legal document. As long as nobody fights it, you're okay. But if someone's unhappy with however you left your will, they can fight it. Now, whether or not they will win is one thing, but a legal document can always be contested in a court. Just determines on how much money you want to spend fighting it. So that's what I'm saying is oftentimes a will is nice. It's good to have because if the family gets along and everybody's okay, you should be fine. It's just when someone becomes upset and angry, that is when problems begin to occur. So even if you have a will, I'm not saying it's going to be peaceful. If someone was upset that they didn't get something or got left out, you could possibly then be fighting it in court. Any other questions?
So
Yes.
the will is basically you still, even though you have a will, you still go through probation, but for the trust, there's no need to go through the legal process.
As long as all your assets in there. Now, with the trust, a lawyer will also create a will, what we call a pour-over will, basically saying anything that got forgotten needs to go into the trust. All right, but the main headache that I get when people go, oh, I have to do that in a trust, in a revocable living trust, is that you have to move everything into the trust name. Okay. And oftentimes I tell people, make sure you talk to your accountant, make sure that this is not going to affect any taxes or anything regarding your business if you move it into the trust name. Because it's no longer in the LLC, you know, it's no longer in whatever name you have it in. So make sure you talk to your accountant before you make that change. And if they're saying, oh, you should be fine, then all you have to do is change it on whatever document with the bank, with the deed, with the Secretary of State to change that. So a lot of people go, oh, that's such a headache. But it may be worthwhile if you're trying to avoid probate and you have property outside of Texas, if you have blended families, or you have a family that you know is going to fight anyway. You just say, I'm moving everything to trust, so when I die, you all can't bicker about who gets what.
So, from the process standpoint, the will is much easier and simpler
Yes,
than the trust.
yes,
right? If
yes.
it's a simple case,
Yeah.
nobody will fight for it.
Right.
Definitely the will is the way to
right,
go.
it is. It's because as long as nobody's gonna fight, all you do is go through probate, which takes a little bit of time. But you don't have to move anything. All the court does is this person has died, here are the documents to show that, and you can now go and change everything that you need to change. Okay, so yes, in Texas, most people will tell you to do the will versus a trust. However, if you fall into one of these categories that you own a lot of real estate outside of Texas, you have blended families, you have a lot of assets, then a trust may be more what you may want to do. Okay. Yeah. Yes, ma'am.
Yeah, I have one question. Thank you for your opinion of the trust that I'm not. The question is, if I have a trust, I'm planning to move everything into the trust. It's kind of a funding. So I think maybe some small things is not necessary to do that. I also have a will.
Mhm.
So will and the trust combination is better, or I can only have the trust to cover everything.
You can have both as long as they are the same. Because basically, in the trust, you're naming who will inherit everything when you pass away. They just don't have to go through probate. So as long as your will and your trust are identical as far as who gets what, then it should be okay. The problem becomes then, if your will says one thing and then your trust says another thing, that's when people are going to start fighting. Your trust will probably prevail. I mean, will be the one that they will look at. But the people who are in your will probably then fight the people in the trust. And that's where it will become a problem having both. So it has to be identical. Everybody who gets everything in the will has to be the same in the trust. Everybody in the trust is getting exactly what the will says.
If we are not sure if it's identical, so I think the good thing is we create the process and we send the will.
If that's what you want to do and avoid probate, then yes. Yeah. And then we would create a will, like a pour-over will, to make sure that any assets that did not get included in your trust will get moved in there. Okay.
So looking at if the things may be too small, we put them into the trust.
You can, you don't have to be real specific, personal items, you can say jewelry, all right, clothing, furniture, unless there's something very specific, like a piece of heirloom or jewelry that's very precious to you, and you want a particular individual to get that, then say who gets it. But if you're like, all jewelry goes to my daughter, blah, 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 then all jewelry goes to that individual. But if you want something very specific to go to a very specific individual, then you need to say it in your trust. Okay? Yes, ma'am.
So continue the will.
Uh-huh.
For the simple case, we still have to go through the probate. But
Yes.
should we still have to must hire the attorney, or we can just
Yes, you
file-
do need to have an attorney to go through probate.
Oh,
Okay.
requirement, yeah.
It does require,
Oh,
it does require, like a will, to draft a will doesn't cost that much, or oftentimes you can do it yourself.
Yeah.
Okay. Now, depending on your estate, if you have, your assets aren't very great in number, you can always call different lawyers and see how much they'll charge to go through probate for you. And it may end up being maybe the same as if you did a trust, or maybe less. It would just depend.
Or different assets, right?
Yes, it really depends on the assets.
Yeah.
Yeah.
So, and for, if you have a business, they say LLC, you
Yeah.
have to create a trust too. Is that considered living trust or different type of trust?
It depends. If you can put your interest in your business in a revocable living trust. However, like I said, a revocable living trust is your social security number. If your interest in your business is a separate social security number, then you possibly will lose whatever benefit you have under that social security number. So because you remember, revocable living trust is your alter ego. It's basically you, your social security is used for tax purposes, not a separate one. So does that cause any issue? That's why I say you would need to talk to your accountant to see if that might affect you moving an LLC into revocable living trust.
Can you separately as your own assets, create a trust? And then for the business, create a trust.
You could, like, let's say this, in a will, if you created a trust where your business would then go into a trust, depending on who benefits from them, then you could do it that way. Okay, but yes, you can always put your interest into a revocable living trust. It's just, will you lose anything tax-wise, protection-wise, if you do that, because it is under your social security number.
You said the tax, so you talk about the tax rebate of that?
Well, how you, when you file your taxes under your LLC, is it under your social security number or is there a separate
Oh.
security number?
I see. So
Yeah.
single member of pass through, yeah, your first.
Right.
So, yeah.
Yeah,
Livia, there's some people online.
yes.
They are asking questions.
Okay.
Okay,
You
the
wanna
first
check one?
question, yes.
Uh-huh.
If parents die, what happens to kids if there's no will?
If the child is under 18, that's why I'm saying you need a guardianship. You need to determine who will take care of your kids. Oftentimes it's relatives, but what happens if your relatives can't take care of those kids? Who's going to take care of your children? Finances is a huge determination of who's going to be willing to take care of kids. Oftentimes it's grandparents if they're alive, but if they're older and ill, that becomes a burden on them. So yes, you must talk about this amongst your mother and father, who will take care of your kids if something happens to both of you.
Thank you. So another friend asked, like, can I move real estate with a mortgage into a trust?
You can. However, if you die and whoever inherits that real estate and there's still a mortgage, they end up paying that mortgage. It doesn't come out of the estate, okay? You take on the debt.
Okay, so another one is, if I want to make a trust, my children who are under 18 years old, good to be the beneficiaries of my annuity account. If I die, they will have to pay a lot of tax to get the money from annuity account.
Okay, now children cannot, and any children under the age of 18 cannot, and they can inherit, but they will not get it outright. It will be put, the trustee of the trust will oversee that asset until that child becomes legal adult, meaning 18 years old. So it will sit there in the trust and be used to pay for education, living, living expenses until the child turns 18, then they will inherit those things. Now, yes, you need to consider tax issues also. Revocable living trusts, or are you going to create a trust in your will where tax issues could be taken care of in that matter? So it really depends on what kind of trust you're going to create for your children, especially those who are under the age of 18. All right, any hands out here?
Yeah.
Okay, no more,
So
okay.
I have more, like, so my IRA account and investment account have designated
Yeah.
beneficiaries.
Wow.
Are my beneficiaries covered without going through probate when I
Yes.
die?
Yes,
But my house in Texas does not have designated beneficiaries. Do I need a trust to cover the house?
you could put it in your will, who will inherit your house, or you can do you can look into this in which county you live in, go to the deed office, see if you can do what's called right of survivorship. It's a form of a deed that when you die, the house goes to in the name of the person on this deed. Okay, then that might avoid probate, but you're going to have to file a new deed to do that. All right.
Okay, so if the will is notarized, then it doesn't need two witness, right?
That's correct. It either needs to be notarized or witnessed by two individuals who will not benefit from you dying. All right.
So can a family member who is not an heir to be a witness for my will? Say my father, he's not an heir,
Like a father, like an in-law, yes.
or your own father or kind of family member who's not
Okay.
there.
Right, your own father witnessing your will, no. Your father witnessing possibly your spouse's will, maybe. But I would try to make it as far apart in relationship as can in your family. Because in-laws certainly are, depending on if they're married to the surviving spouse, no. It's just, if you're going to benefit from someone dying, whether through marriage or something like that, I would say do not use them as your witness. Use a friend, use somebody at, oftentimes notaries or at banks, use somebody at the bank. It can be anybody, as long as it's not someone who will benefit from the will.
Yeah. Do we have more questions here in the office?
Yes, sir.
Gentlemen?
So what's your tax implications? So if you have an escrow and you put it into the escrow into your trust, so that's not a problem because you're going to flow through.
Right.
Right?
Right.
What if you have a LLC or you have C corp?
See, that's the thing that I'm not an accountant and tax is not my specialty. That's why I would say, please talk to your accountant first before you move any of those types of assets into a revocable living trust. Okay, talk to them first and see if you lose anything, or if you don't, then there shouldn't be a problem. My whole concern with those is, are you going to lose something, a benefit, if you move those types of assets into a revocable living trust? Okay, so I would say talk to your accountant first.
So second question, if you just sign a trustee
Yes.
and for your underage children, will they automatically get a percentage of your asset as compensation for?
Only if you say that in your trust. Now, oftentimes family members will not require a percentage. What they may ask is if any administrative costs, things that get filed or nominal fees, they may ask those to be covered. But oftentimes it's not a percentage of the assets. Oftentimes it's like an hourly, like if you get a lawyer or a CPA, it may be based on how much they charge per hour. Then your state will pay for that, through the trust, will pay for that individual's fee.
But you can assign a certain percentage as a
You can.
incentive for them to take care of it.
Yes,
Perfect.
you can do whatever you want in your trust because that's your trust, but you don't have to. Okay. Now, you certainly want to put someone down as your trustee, someone you can depend on, but certainly, if you want to make sure they do the right, good job, then you can do whatever you want to do. Okay.
So if your first layer of the trustee, your parents, if they are going to grow, they can assign to your secondary.
Right, yes, they don't have to die. If they say, I just can't do this anymore, then whoever your alternate is, then I would put it in your trust, because you put the main trustee and then you can put alternates. And then they can take over.
Can you talk a little bit about the cost or how
Okay.
complicated or what's the
Depending
system?
on, okay, I would just say this with trust. Depending on how much assets you have and how complicated it will, determines costs. Okay, if you have lots of assets, it's going to cost you some money to pay for a trust. I mean, to get a trust created. If your assets are rather nominal, not a whole, like it can start off from 1,500 and up. I would say 2,000 is probably the minimum, and then it can go up from there.
Okay, so for each additional real estate or business or something,
Right.
you just put on top of it.
That's exactly right. Because if your person you hire also does the deed transfers and does all those headache things for you, they will probably charge you a little bit more for all to take care of all that also. Which you may think, well, it's worth it. That means I don't have to take care of it. I'd rather have somebody else take care of it for me. So then that cost then may be worth paying for.
How do you keep your trust or will private? So you can.
Okay, well,
benefits you won't know until.
Right. Well, you'll want to know, at least tell whoever, hey, I have a safety box.
Mhm.
And when I die, you can go to that safety box and find all the paperwork that's necessary. And they can't go to your safety box until after you die. So they have no idea what's in there. Now, oftentimes people give copies of their will or trust to their executor, the person who will be taking care of things, or their trustee. So they will see who is in there. But if you're like, I don't want my kids to see, I don't want my spouse to see, especially if there's someone you've left out of your will and you don't want them to know until you're gone, hey, I cut you out, you're not getting a cent from me. You know, you don't have to share any of that with anybody. Really, the only person who's going to know is whoever drafted everything. Now, lawyers are supposed to keep all that private. And then you would hope that your executor, you also could say, look, I need you to keep this private until I die. You're in charge when I die, but until then, this is between you and me. Or you just have a safety box somewhere and you keep it in there and tell your family, hey, I got a safety deposit box, and when I die, you can go in there and everything will be in that box.
And they give to attorney or somebody or accountant or something.
Well, if on your safety deposit box, I'm sure there's somebody when you get one who will have authority over it if you pass away, or if you have power of attorney, you've given power of attorney to someone. A safety box, I think, would be included in that power of attorney if you want them to have that authorization.
Can you talk a little more about the, like medical or health arrangements in the trust? And you can do that as part of it, right?
Yes, in a trust, you can do whatever you need to do. Now, when you talk about medical, what do you
Yeah,
mean
like,
exactly?
when you're incapable.
Okay.
Of who's gonna make
Okay.
decision on those.
So in a trust, a revocable living trust, it doesn't have to come into existence just because you die. You can also create the trust if you become incapacitated. So whoever your trustee is in your trust can take over just like a power of attorney until you are better, okay? So during that time that you are unable to make those decisions, your trustee in your trust will handle everything until you become better, okay?
But you can also specify to the trustee or who is secretary that to what extent you will be saved or supported and you don't want to be saved.
If that's who you want to make the decisions, okay? Those medical directives, you designate who is going to make that decision. Oftentimes it's your spouse, okay? It's your spouse, your husband, your wife is going to make that decision, all right? Now, if you're like, oh my gosh, I love my spouse, but they may be too emotional or they won't make the decisions that I want them to make if it comes to them making it. I would rather have my daughter who's a doctor to make that decision, or, you know, somebody else in the family to make that decision. Now, your spouse is going to have to, they may not like that, but if it's a legal document, the doctor's going to ask, all doctors always ask, is there a medical directive? Does this person have one? If they say yes, we need to see it so we can see what it is they want done. Because the doctor will follow it for sure. All right. Now, of course, family can always fight it. You hear those oftentimes when someone fights it, they don't want life support taken off. They don't want it to stop. We're going to court, but oftentimes the court is going to look at what you wanted and go based on your wishes. Okay. So if it's your trustee of your trust that you put in your directive of who's going to make those medical decisions for you, yeah, you can put whoever you want on there. Okay.
You have a list of questionnaires that for us to consider to complete we will not forget important stuff.
I do. If you wanted me to draft something for, I have a checklist of everything so that and we would talk about it, about, you know, a lot of people's personal life and business life is very different. I don't judge anybody, certain things going on in your personal life and you don't want other people to know about it, you know, it's private. And if you're like, I don't want my spouse to make these decisions for me if I'm not able to, then we'll talk about who it is you want. And that's who we'll choose. It's your decision. It's your decision. And that's what I'm saying. If you want these things done and you want it done a certain way, you've got to plan for it. Because if you don't, then the law is going to dictate who's going to make those decisions for you. Okay.
Yeah, so one question online.
Uh-huh.
So if I put a real estate into a trust, can I get a rent from that estate, or I have to put the rent into the trust?
No, you can use that rent money. I mean, that's income. It's the real estate is in the trust. all your accounts are going to be in the trust's name. So if you have bank accounts that you're going to put that rent money in, it's in the name of the trust. You as the trustee can write a check, but it's always going to be under the account of the trust. It's not going to be your own personal account that this money is going to go into. It has to go into an account that has the trust as the account owner.
Oh, so that he wants to just know, so if the real estate in the trust, so he still can get the rent
Yes.
from that estate.
Yes,
Okay.
yes, yes. Remember, it's your alter ego. It's you. The trust is you. All right. It's just that it has to be in the name of the trust. All your assets have to be in the name of the trust. Your real estate, your bank accounts, everything needs to be in the trust name, but you control everything still.
Olivia has one question.
Okay.
This is one
Yes, sir.
question for the
So I have two questions.
Okay.
two questions.
First question is, some of us may have some international businesses or properties. What's the rule of thumb?
Yes, a trust and a will probably, you can put it in there, but you're still probably going to have to go into that country because the United States will deal with the United States law, but anything in a foreign country, maybe you may have to hire someone in that foreign country. Oftentimes when I tell clients that, they go, oh, well, maybe I'll sell it before I die, so I won't have to deal with, or whoever is left, my heirs won't have to deal with it in the other country. So oftentimes I hear, well, maybe I'll sell it before I die, or I'll take care of I'll have a plan in place so that when I do die, this is what will happen. Okay, yes, because we don't have a reach into the foreign countries to tell them what to do. We may have something to show them, but whether or not they'll follow it, we may have a harder time.
And the second question is, I look at your meeting notice or your advertisement. You have two parts of your answer, and we didn't hear the second part. Are you going to elaborate on this?
What second part?
Second, we are just, I think it's maybe more like what is the probate, right? What's the cost?
Oh, the
The
process.
process.
Okay, probate is okay. Probate only comes into play if you have a will or don't have a will. Okay, those are the only two times. Now, some people are like, oh, I don't want to do it. It costs money. I'm going to have to hire attorney. Well, if you don't go through probate and you have a house and the deed is the name of you and the dead person, you cannot sell that house, okay, because that person's name is still on the deed. You're going to have a problem being able to liquefy or sell things if the dead person's name is still on the account or on the deed. So you're going to have to go through some court order still to get that resolved. So that's what probate is. So what probate is you file an application with the court. You say so-and-so has died. These are their assets. I want so-and-so, and then the court will ask, is there somebody that you want to be the independent executor? Oftentimes it is their surviving spouse or someone in the family or a trusted friend. It basically is a process to say, this isn't somebody coming in, making something up and trying to steal somebody's property. This is to make sure that the person has died, the court legalizes that death, and therefore all assets under the deceased person's name now can be transferred to the heirs. Now, a court may determine if there is not a will, who those heirs are, okay? Especially if there's no surviving spouse or there's a blended family. The court will then determine who gets the community property and who gets separate property, okay? They can determine the heirs. If you have a will, basically the judge say, okay, independent executor, you now have the right to disperse the assets as the will says. It's a case over. So determining how complicated the case is, if nobody's decided, it should just take a few months to go through probate. But if you're going to have people fight over everything, whether will or not, it could take a long time. Depending how long, And really, I'll tell you this, and then this may seem cynical, as long as there's money to pay a lawyer, they will drag that thing out until the money stops, and then they're gonna be like, okay, it's time to move me to work something out. I'm sorry, that unfortunately seems to be oftentimes the case. Or you go to mediation and then you try to work something out, but oftentimes things work out when the money, people are tired of paying lawyers or say, we've spent more money than I'm going to inherit. So it's time to resolve this.
So what's the average price for probate in Texas, let's say?
I would
now.
say, right, it's similar like creating trust. If you have a will, probably much easier. I would say, I would say average is 1,500. You could probably find lawyers who'll do it for less, and you may find lawyers who may do it for more. It just means you need to call, I'll ask people that have gone through probate, have gone through this process, say, hey, how'd you like your lawyer? Did you have one? How much did it cost you? And you may call some people, other people, just to kind of get an average. And oftentimes people hire lawyers that they like or they get along with. Oftentimes people go, well, I'm going to go with the cheapest. Well, sometimes you get what you pay for. All right, so be careful with that also.
So
For
people,
the probate, the charge is based on the percentage of your
It
asset.
can be. If you have quite a large asset, it will be a percentage. It will be a percentage versus an hourly and a retainer. If you have quite a large asset, it will be a percentage of your estate.
So it will be money you drop the trust rather.
Yes, possible. Yes, possibly.
so what do you consider, what's your definition for large one? Like, let's say
I would say
100K or
I
150?
would say $1 million plus.
Okay, million plus, meaning house-wise?
Anything, everything.
Some people have life insurance like
I know, okay,
over
but
a million.
I don't think life insurance is considered part of the.
So,
Yeah.
so if the house, like a real, a lot of Asians like purchasing
Yeah.
houses. So usually like the houses together probably worth million.
Yeah, so if you pass away and you have a will and instead of a trust, whoever's going to go through probate, that attorney is going to charge probably a percentage of the asset, because you have to turn in an inventory to the court of the individual's assets. All right, it can't be secret. In the court, you've got to give a list of your assets. So people will know at that point then how much you are. And oftentimes, so when a lawyer takes the case, they're going to know. And they're going to ask, they're going to say, this is in our contract says, I'm getting blah, blah, blah percentage. And usually it's mom to dad have it.
About 1%, like sitting in the trust. 1 to 2% depends on the amount of.
In the trust, right, of the
Which
asset.
including the stock market, your stocks, your real estate. your-
Cash.
Yeah, cash. But your personal jewelry is not there, but the personal jewelry is under the insurance, like property insurance, right, that would cover.
Yes,
What percent? 1 to 2%?
Yeah.
Yeah.
I mean, it doesn't seem like much, but if you've got, quite a bit of assets, lawyer could end up getting $10,000 to $25,000 for doing your probate. Now, that's a pretty good chunk of money, for going through probate.
Is it worse? Because, a lot of Chinese people, Asians in general, have several rental properties. And they just feel like, probably I will sell them, some of them are in 2 or 3 years. Is it worth setting up a trust?
You could do, if you sell your property, it's no longer in the trust. So you do whatever you want with that property, it's just no longer in your trust.
Okay, so even though they put those properties in the trust.
Yeah.
And when they sell, do they need to pay extra money for like attorney?
No, you don't have to. It's like you're the trustee of the trust. You sell that property like you are the owner.
Okay, yes, because a lot of people who have a lot of real estate properties have that concern. I'm going to sell those properties. Why should I set up trust?
You don't have to. It just depends. The trust is mainly that if you die, okay? This is all in preparation if something happens to you, all right? Okay, a revocable living trust means you don't go through probate. Your trustee will take care of all your assets and you don't have to go through probate. The trust is only comes to play when you die. You still have control over all your assets in your trust if you are the trustee. You do not lose control, so you can still do whatever you want with your assets. It's just now in the name of the trust. So if you want to sell your property, you can sell your property. It just means that whoever was going to benefit from that property, if you died, well, there's no more property there for them to benefit. That's all that is.
Okay, thank
right.
you.
All right, we got 5:45. If there's any more